In the year 1970, an extensive federal law was passed by Congress. This law is called the Controlled Substances Act, which classifies marijuana in the most restrictive category, which states that the cultivation, distribution, and possession of this product is a federal crime. The federal government gives no exception to the association of this drug. As the CSA states, this drug is still a crime even if the cultivation, distribution, and production are for medical purposes. The Federal Administrative Enforcer of the CSA, the Drug Enforcement Agency, has agreed with Congress on the dismissal of suspending any enforcement against any person who handles the drug against the state medical laws. In United States v. Oakland Cannabis Buyers Cooperative, the Supreme Court postponed Congress's stubborn decision that marijuana has no medical benefit and has established that the CSA leaves no opportunity for an exception of a common law on medical marijuana. In 2005, the case of Gonzalez v. Raich strongly asserted the constitutionality of the CSA even when tested with marijuana-related activities that were localized. Raich's issue was if the ban of growth and consumption of marijuana where the marijuana was grown locally with only local stimulators and didn't get involved with interstate markets would interfere with the Commerce Clause permitted by Congress from the CSA. The respondent had association with the growth and consumption and was in relation to the California CUA, which states that the possession of marijuana is prohibited only when not approved by a physician for medical use. In a 6-3 decision, the court was capable through Congress's Commerce Clause to regulation because the activity could have a high impact on the interstate market. Justice Scalia joined Justices Kennedy, Stevens, Ginsburg, Souter, and Breyer to get the majority vote. This is one of the few times that conservative justices sided with the others to legalize illicit drugs. The case began by notifying that the respondent did not debate whether Congress had the power over marijuana for non-medical uses. The respondent actually argued that the CSA prohibition of marijuana interferes with California's laws which exceed Congress's authority under the Commerce Clause. The court reasoned that banning the growth of marijuana for medical use was to prevent and/or limit access for other uses. A concurrent opinion by Justice Scalia had affected the decision from the previous cases, United States v. Lopez and United States v. Morrison, and their results. In these earlier cases, Scalia voted in favor of limits on the Commerce Clause, whereas in this case, Scalia voted with Raich for the Commerce Clause and the understanding of the Necessary and Proper Clause. Mainly, the consumption of marijuana has a serious effect on supply and demand in the national market, which is why Congress clearly has commerce power over the production. Raich and Monson stated that they were both intending to continuously use marijuana for medical use in defiance of the ruling and federal law. A few days after the case, the International Narcotics Control Board declared that the cultivation and use of marijuana, even if for medical purposes, will still be prohibited. Then, Hamid Ghodes, the NICB president, explained that cannabis is classified under the international conventions as a drug with a number of personal and public health problems, indicating the single convention on narcotic drugs. Congress has voted multiple times against Representative Morris Hinchey and Dinah Rohrbacher's decision to keep marijuana patients safe from being arrested or prosecuted by the Department of Justice. In 1996, California passed Proposition 215, which was the nation's first medical marijuana law. To receive the medical marijuana, patients must have a written or oral recommendation from their physician. In 2003, limits were set for eligible patients and their caregivers for the possession and cultivation of marijuana. Each patient is given a medical marijuana ID and is required to show it when necessary. To be eligible for the drug, patient must have an illness like arthritis, cancer, chronic pain, HIV or AIDS, epilepsy, major migraines, multiple sclerosis, and/or other illnesses recommended by doctors. The patient is only allowed to have up to 8 ounces of marijuana unless doctor recommends more. If patient has cultivated land for growth of marijuana, they may only have 6 mature or 12 immature plants. The dispensaries for patients are state licensed but are not allowed to be within 600 feet of school nor be regulated for personal profit. Approximately 20 other states, along with the District of Columbia, have laws allowing the use of marijuana, whether medical or personal. Each requires patients to have some kind of illness or issue, though the amount of states to go against federal law is still increasing.
Ending our failed prohibition of marijuana and instead legalizing, regulating, and taxing adult use. Alaska and the District of Columbia voters joined Colorado and Washington from 2 years earlier with strong votes to legalize.
Because Congress wants to keep a positive aspect on cooperative federalism, they will most likely not attempt to fight states on their drug laws and try to take them away. It is also highly unlikely that the federal government will be able to persuade state agents into enforcing policies against medical marijuana. Cooperation between the states and the federal government is critical, especially under the CSA. Federalism can be considered as cooperation under the state and federal government because, as one student states, state-federal partnership in carrying out federal policy is considered cooperative federalism, also showing that the federal government relies on states and they do not agree on this topic. Though the federal executive has attempted to overthrow the state medical marijuana laws, it is no longer supported because there is not enough resources to continuously try to eliminate all dispensaries working with the California state law or any other state for that matter.